the next thing on the agenda, which is the section of the guest lecturer, may I humbly invite Dr. D. Ilorin to handle that. Let us give him a warm up of his comfort.
Honorable Justice the Vice Chancellor, the Deputy Vice Chancellors, the deans here present, my lords, Honorable Justice MMA Akanbi, I want to take your leave, sir, my lord, to read the citation of Honorable Justice Kareem Adedokun. It is with great honor and profound respect that I present to you Honorable Justice Dr. Kareem Adedokun. I'm sorry, my lord, I've not asked you to stand up, sir. I've not asked you to stand up. It is with great honor and profound respect that I present to you Honorable Justice Dr. Kareem Adedokun, a luminary in the field of law, whose profound insights and unwavering commitment to justice make him an extraordinary figure in our judicial system. As he prepares to deliver a public lecture at the esteemed Faculty of Law, University of Ilorin, on a topic of immense contemporary relevance, navigating the digital divide, how artificial intelligence can enhance access to justice. We are reminded of the vital role it plays in bridging the gap between law and technology, and the just application of both of them in our society. I know if I had before my noble Lord, I will stand addressing your Lordship and remain standing. But today, sir, I want you to stand and remain standing, sir. Why I read your citation? The Lord, Honorable Justice Kareem Adedokun was born on the 24th May 1968 at Sobalodi Compound, Sando, Aguare, Oyo State. The journey of my Lord began in humble settings, where he was instilled with strong values and a relentless pursuit of knowledge. His academic journey is marked by excellence, earning his PhD from the prestigious Ahmad University area in 2011. Prior to that, my Lord dazzled the academic community at the Nigerian Law School, where he obtained his Bachelor of Law in 1999 and later his Master of Laws LLM in 2006, also from ABU Zaria. Most importantly, I'm proud and very pleased to inform this noble gathering that the strong foundation for the immense legal, academic, and judicial knowledge and wisdom of our guest lecturer for today was formed, built, and firmed up right here at the Better by Far Faculty, the Faculty of Law. This faculty laid the groundwork for his distinguished career in law and academia. My Lord, Honorable Justice Adedokun brings the wealth of knowledge in both judiciary and academia, reflecting his multifaceted expertise. Since his appointment as the High Court Judge of Oyo State in 2021, he has served in various judicial divisions, including Ogbomoso, Orile-Igbon, Kisi, Iseyin, and Saki judicial divisions, where he has upheld the rule of law and advanced the cause of justice. His roles have also included serving as his vacation judge across multiple divisions, demonstrating his dedication to ensuring the continuity of judicial processes. My Lord, Honorable Justice Kareem Adedokun is not only a profound jurist, he is equally a thoroughbred academic and has contributed significantly to the academia. The Lord Honorable Justice Adedokun rose to the status of Associate associate professor of law at the Kwara State University before joining the bench. His teaching not only covers all legal subjects but extends to critical areas such as tax law and international business law, reflecting his commitment to fostering the next generation of legal practitioners. His leadership roles with the university, including serving as the head of the Department of Business and Private Law. His teaching acumen also earned him accreditation as visiting senior lecturer at Crescent University, Abeokuta between 2014 and 2017. My Lord, Honorable Justice Kareem Adedokun has supervised master and PhD students. He has equally delivered scores of judgment since his assumption of judicial duties. This speaks to his work ethics. His contributions extend beyond the classroom and courtroom. He is recognized member of several prestigious legal and professional associations, including the Nigerian Bar Association, where he served as a member of the National Executive Committee from 2006 to 2008. Miller is a member of Charter Institute of Practitioners of Nigeria, where he was conferred with the prestigious status of Fellow of the Institute in the year 2020. His commitment to the development of the jurisprudence of tax law in Nigeria was the reason the CITN appointed him as the Acting Director General Adjunct for his tax academy from 2020 to 2021. The involvement of my Lord in all these organizations underscores his commitment to the ongoing development of legal practice and policy in Nigeria. Also, due to his commitment to substantive justice and an ambassador of peace, the Kaduna State government appointed my Lord as a member of the Kaduna State Board of Alternative Dispute Resolution Multi-Door Courts. And he served in this capacity between 2014 and 2017. The scholarly work of my Lord is equally impressive, with numerous publications in renowned journals and articles such as tax obligation and state legitimacy, a critique of the disconnect between state demands and people desiderata, and impact of technology on admissibility of photographic evidence, Nigerian perspective, illustrate the deep engagement of my Lord with pressing issues in law, particularly those at the intersection of technology and legal principles. In today's society, the integration of technology, especially artificial intelligence, plays a pivotal role in reshaping our understanding and implementation of justice. As Justice Dr. Adedokun prepares to address this topic in his upcoming lecture, it is essential to reflect on his vision for leveraging artificial intelligence to bridge existing digital divides that hinder access to justice, particularly in Nigeria. The Lord Honorable Justice Adedokun's innovation and innovative perspective will undoubtedly inspire legal scholars, practitioners, and students alike. His commitment to using technology responsibly and ethically will contribute to shaping a legal landscape where access to justice is a fundamental right for every individual, irrespective of their socio-economic background. As we anticipate my Lord Justice Dr. Kareem Adedokun's enlightening lecture at the Faculty of Law, we recognize not only his vast contribution to the legal field, but also his vision for a more equitable and just society. His insights on navigating digital devices through the lens of artificial intelligence will serve as a beacon for all stakeholders in the legal profession, urging us to embrace innovation while remaining steadfast in our commitment to justice. Thank you all for joining us in this celebration of a distinguished legal scholar and practitioner. We look forward to the profound insight and transformative ideas that Honorable Justice Kareem Adedokun will share with us as we collectively seek to enhance access to justice in the age of digital transformation. Permit me to invite our guest speaker, Lord Honorable Justice Kareem Adedokun.
Thank you.
Good morning, ladies and gentlemen. Wherever a judge is sitting, it is taken to be a courtroom. And all the decorum that is expected in the temple of justice should be accorded such a judge. I'm talking to our students. Sit down and want to go out the world quietly without disrupting the course of this proceeding. That is the training we receive, and that is what has shaped our lives today. Now you sit down, listen, or you want to go out, you go out quietly. Before I go into the protocol, I don't know whether it is a sheer coincidence. This time, last week, was when I was at another institution that built on what the University of Ilorin, the foundation this faculty laid, Ahmadu University. About 8 or 7 days after, this is another homecoming. The first chancellor has left, and when the first chancellor was delivering his speech, he said, I have close relationship with Adedokun. President Bowale, my teacher, my mentor, and my benefactor. Here in the Faculty of Law, I left this faculty 25 years ago. With the likes of Professor Mipidan, Professor Yemi of Unilad, Professor Luke over here, Professor Folashade Adedokun of Unilad, and lots of others. When we left people like Dr. Ariyoshi. President Bowale taught me law of evidence, taught me complete of law. In conjunction with my teacher, my mentor, similarly. Thank you very much. All the DPCs have left the university management. The Dean of Law. The Dean of Law taught me before President Bowale taught me. President Bowale taught me 400 level. The Dean of Law taught me 300 level, landlord and tenant. The teacher and our disciplinarian. She believes in education and discipline as what can shape the growth of the students. And today, we don't regret the training that we learned from you. Thank you very much. All the deans here present, the Dean of Art and others have left. I was to be in Faculty of Arts in 1990 when Faculty of Art offered me admission, but I ran away. I wanted law, I don't want art. And here I am. All other professors here present. I've seen my colleagues and other teachers here. I can mention names of all of them one after the other. Professor Adam is here. It was at the time I was enjoying sucking the milk of learning more about the university administration that judiciary snatched me away from Professor Adam. Professor Adam, thank you. Professor Najib Ijaya, and the immediate past then, Professor Ijaya. Thank you very much. Please, I would request that we have a minute silence for another mentor, Professor MMA Akanbi, Senior Advocate. May his soul rest in perfect peace. Apart from being my teacher here, don't make complaint of. Since then, you know, when you are a teacher, you have hundreds of students in class. You go as a training. You go at the pace of the one that has the lowest intelligence in class, so that you'll be able to benefit from the lecture. As a time we were here, we wanted to read law, and we found ourselves in faculty of law. We happened to be the pioneer set here. But we did not know. But our teachers noticed that, oh, this set of people, they have certain form of shining stars hovering over their head. One after the other today, we are seeing the manifestation. I kept that faculty of law, you know. Professor Akanbi, after that, I remember when I finished my PhD in 2011, and after the minor corrections, I was going to submit the final copy when the phone rang and I picked. Alas, it was then Dr. Akanbi. Adedokun, when is your Bible? I said, okay, I did it last week, and in fact, I'm going to submit it. When could you get your so-so-so? Please proceed to so-so-so for appointments. I was to be at last week. But another senior, I'm mentor to him too. Now said, no, I don't want you in last week, but you go back to Kwasu. And that's where I found myself in Kwasu. As fate we have it, Professor Akanbi again came to be my boss. And he was the first chancellor of the Kwara State University when my name was announced as the judge of High Court for your state. I did not allow anybody to break the news to him. I walked in straight with my friend, the Marshal, to meet him and he said, oh, I will not allow anybody to broadcast this news. I will do it myself. Whatever thing you read about that appointment on social media then was penned down by Professor Akanbi. May his soul continue to rest in peace. My Lord, Honorable Justice Akanbi here present. My Lord, Honorable Justice F.F. Abdulrazak. I remember Usiapadi taught me in this faculty, President Jawdrola, about jurisprudence. And I still remember that phrase, that when all pretenses are removed, judges judge with what is on their mind. Remove all pretenses, come and move application before us. Come and argue whatever you want to argue. I will know the truth through me and I will judge with that, and I will find a way of getting it within the principles of the law. When you argue anything, and when you have any opinion as this is the law, it is not the law until the judges pronounce it to the law. My Lord, Justice the situation has changed now. You see, when one happens to be a conductor, and they now ask that conductor, "Where come and drive this car?" A lot of things have changed. Your perception will change, your vision will change, your orientation will change, your commitment to work will change. You are at the bar. I know that by now you are seeing the bar differently from when you are seeing it there. Women, I know Professor Akanbi and others there. Thank you for coming. The worship here present, I've seen my colleague, her worship, Dr. Barajay, other colleagues here present. Let me particularly recognize the presence of NBA members here. I was secretary of the branch. I was the first chairman of the branch. I was the chairman of the branch and NEC member for years. I used to leave the bar to go and confront the judges politely. Because by that time we'll be in court 9. But your morale will be down when you are in court 11 and no register comes out to tell you my lord will sit or my lord will not sit. Then we say, we can't continue like this. Please, sir, tell us the time you will sit. Because one of the things we sell as lawyers is our time. We have searches we want to conduct. We have letters we want to write. We have meetings that we want to go and represent our client. Now, I found myself in that position. Do I have any excuse for not sitting 9? I don't have any excuse. Members of Kubumashoba, thank you for coming. This is a big surprise. Please stand up for recognition. Thank you very much. Mr. Elijah and others, this is a very shocking surprise. Deliberately, I did not make mention of it that I will have this thing in open court, very unlike me, because I used to talk. Thank you for coming. And at least some of the things that we will interrogate here, you'll be able to say whether what I am saying is true or not. A great Nigerian student of Faculty of Law. At the time, it was when I came to read law that I stopped student unionism. Because I was the only one there, the only Muslim from my community that had opportunity of coming to read law. And I reflected on what I did while I was at College of Education, the kind of activity. Said if I should repeat that here, and I have the cause for the university to say go back home, it will be a disgrace to that. Quietly, I did not participate. I now went back to the NAMAS then, which I led until I left this faculty. I will have appealed on your behalf to the Vice Chancellor. The person I know, the Vice Chancellor that I know, the Professor that I know, is not a person that used to be unnecessarily rigid. But I think his hands are tied. However, at my own level, whatever I can do, I will still appeal to him on behalf of. The family of my Lord Honorable Justice Mustafa Akanbi, I think I have 2 instances of meeting Baba. One was when I was in 300 level here, and Baba was to bow out of the judiciary. That was when the Court of Appeal Ilorin Judicial Division was established. And we were asked to go there as students. We were there and I listened to his speech. He said for years, some of his juniors were being elevated to Supreme Court and they left him and he never complained, not knowing that they wanted to use him to head that court, having seen the quality in him. And he said he did not regret. He never influenced his post-it. And I remember he was telling members of the bench then that wherever you are posted to, don't influence it. It may be blessing in disguise. And I remember I was asked that question at NDAC. How many judicial divisions have Oyo State? I mentioned the one I remember. Which of the divisions can't you work? I said, as a lawyer, I've appeared in Katsina, I've appeared in Kano, I've appeared in Jos, I've appeared in Abuja. If as a lawyer I can traverse the length and breadth of Nigeria, Oyo State is small. There is no judicial division I cannot work. If it's a judicial division of Ireland. That's the type of person. And I remember, in the course of one of our private discussions with my mentor, Professor Akanbi, I remember he told me when he wanted to serve during his NYSC. I think it was to serve at CBN. And when they heard that, oh, the son of then President of Kareem, just go and get a note that we identify you that you are from Baba, you are his son. And that was the note that Baba Akanbi will not write. If they want to give you, they find you worthy of working with them, they should, not because of my influence. That is the type of person that we have in Baba Mustafa. May his soul continue to rest in peace. Ladies and gentlemen, the gentlemen of the press, please, whatever I say, please don't blow them out of context. Please, our job is very, very sensitive. Whatever we say is very, very, it will attract weight. A judge is saying this, a judge is saying this. But I will not say because of that, I won't say the truth. Ladies and gentlemen, I consider it a singular honor and privilege to be invited to this esteemed event of the annual public lecture in honor of the distinguished guest, Honorable Justice Muhammad Mustafa Akanbi of blessed memory. Presenting in this setting does not only allow for the dissemination of knowledge, but also fosters meaningful dialogue among the participants. It's a chance to connect with individuals who share a passion for the subject matter of this discourse. As we delve into the topic of this presentation, we embrace the responsibility to inspire thoughts, to provoke discussion, and to contribute to the ongoing conversation surrounding the need to accelerate adoption of artificial intelligence in practical, life-improving solutions, particularly on access to justice. Let me state from the outset that Honorable Justice Muhammad Mustafa Akanbi was an influential figure whose impact on the legal field and judiciary is undeniable. And as such, this paper pays tribute to his lordship's esteemed contributions, his unwavering commitment to justice and the rule of law has left an indelible mark on our legal landscape. His profound insights into the complexities of knowledge of justice not only advance legal thought, but also inspire countless individuals to pursue equity and fairness in the legal system. As we reflect on his legacy, we are reminded of the essential role that dedicated jurists play in upholding the ideals of justice to serve the public good. I divided the paper into about 5 subsections. 1, we need to understand the digital divide, and we need to see the gap in the digital divide. Thereafter, we need to see what is the impediment of this divide to access to justice. Thereafter, we will examine the problem of access to justice. Why is it that when you have a case, particularly in this era of front-loading, I find it irritating. And lawyers here can testify, I find it irritating. I remember when the Chief Service Commission of Oyo State asked me, looking at my CV, and they asked me, please, what are you coming to do in the judiciary? And I told them I am coming to make impact, positive impact. There are a lot of things I've seen going wrong. We can't continue to pay lip service to some of these things. When you have opportunity of being there, please be the change that we need. Please be that change. So we need to see access to justice. The problems, why should it matter, particularly in this era? Why should a civil matter be before a judge for 7 years undecided? Tell me the kind of society tell me the kind of individuals, tell me the type of foreign investors that will have trust and confidence in that kind of system. Now we look at some of these problems, what is causing the delay, and host of others. When we look at them, let us see the intervention of artificial intelligence, how artificial intelligence can obviate some of these problems. Thereafter, we'll go to suggestions and we'll conclude, we'll round up. All this, I promise you, I will do it within a short period of time. Now, let us look at why we need to understand the digital difference. When we're talking about exploration, the evolution of navigation reflects humanity's quest for exploration and our ability to adapt to new technologies, shaping how we travel and connect with the world around us. The history of navigation is a fascinating journey that spans thousands of years, evolving from simple methods of sophisticated technologies. Some key milestones are the ancient navigation, the age of exploration, that's in the 15th and the 16th century, where European explorers like Christopher Columbus and Vasco da Gama, they relied on compasses, on maps and stars to navigate uncharted waters. I remember the era of sextants and chronometers up to now that we are in modern navigation. For some of us that are above 50, I remember when I used to follow my dad to the farm. Particularly during rainy season, sometimes you will be on the farm say around 2 o'clock, no sun. That time, the only thing that we have, the only instrument that we reach out and grab is the wall that is at home. That one that used to have one big pendulum like this. So my dad will look at his shadow and will tell us, this is time for sorrow. I think this is surprising. How did this man know? If we are there at the asking period, he will tell you, this is the time. The technology they have there was what he was using. Now, where can you be now that you will not put Qibla finder and straight away your Qibla will quickly be pointed out? That is the work of technology. Today, navigation is largely digital, with smartphones and apps providing real-time direction and traffic updates, making navigation more accessible than ever. The expression digital divide implies the gap between the individuals who have affordable access and skills to modern information and communication technology, which support them to effectively engage online, and those who do not. A lot of people, they have access to internet connectivity. We have a large number of people that do not have. Definitely there is a divide. Definitely there is imbalance. Available statistics put it that UNICEF confirms that about 1.3 billion children between the ages of 3 and 17 do not have access to the internet at home. According to UNESCO, approximately 45.2% of the world's households do not have access to internet. As of January 2023, a statistical study revealed that about 38% of Nigeria's population has access to the internet, compared to that of the United Kingdom, where 93% of the population has internet access. Let's consider it from gender perspective. Another recent report has it that only 40% of women against 62% of men are aware of mobile internet, thereby precluding internet use for over half of the population. Even for lawyers and legal profession, digital divide constitutes a significant challenge which may engender unequal access to legal information and services. According to the National Bureau of Statistics Telecoms Data Report, for the first quarter of 2024, Internet user penetration stands at 42.65%. Nevertheless, this statistical data indicate that digital divide hinder many Nigerians from accessing relevant information that can particularly assist in access to justice. Therefore, navigating this digital divide entails how do we address these disparities in access to legal resources and information that technology can provide, particularly using artificial intelligence as a tool. Now there is a divide. Now there is disparity. That's divide. That's digital divide, and its impediment to access to justice. The essence of justice to humanity entrusts the pursuit of fairness, equality, and moral rightness in society. Justice serves to uphold individual rights, ensure accountability, and maintain social order. It embodies the data that everyone deserves to be treated with dignity and respect, regardless of their background or circumstances. Let me pause here a bit. I have some colleagues that where they post them to a judicial division, I had them discussing that the cases there, they are useless cases. And one day, I could not stomach it again, and I asked, Melody, I asked, which case is a useless case? You are saying the kind of cases that these people are fighting over does not have meaning. It has meaning to them. They agree, and they believe the only area where they can go to ventilate their grievance is in the court. Whenever they come, the door must be open to them, and we must give them access to come and ventilate their grievances in court. From the Holy Scriptures, it is on record that Quran emphasizes justice as a sacred duty, and the Almighty Allah commands believers to uphold and stand firm for it. Even in the Holy Bible, it makes justice as a major theme by emphasizing establishing right relationship with others and having unbiased relationship with the truth. In essence, the conceptual connotation of justice evokes the protection of the weak and the promotion of the common good in order to contribute to a more harmonious and equitable society. Ultimately, without justice, the fundamental principles of fairness, the fundamental principle of equality that hold society together will be eroded, and this will result in chaos and anarchy, as people may resort to protest and violence to seek redress for their grievances. The essential nature of justice to humanity makes the Constitution to protect it by setting an affirmative framework necessary to giving practical content to its actions. Besides, the Constitution giving us the framework, there must be substantive and procedural mechanisms existing in our society designed to ensure that citizens have the opportunity to seeking redress for the violation of their legal rights within the Nigerian legal system. Access to justice is a fundamental principle of law which ensures that individuals have the ability to seek legal remedies and have their cases heard in a fair and impartial manner without undue delay. In the perspective of OECD as Organization for Economic Cooperation and Development, access to justice refers the ability of the people, the ability of business, the ability of communities to prevent conflicts and obtain effective, fair, equitable, and timely resolution of their legal and justice-related needs. Although the rule of law requires impartial and non-discriminatory justice, it also obligates legal empowerment, which enables meaningful participation in the justice system and builds people's capacity to understand and use the law. Little wonder then, the Constitution of the Federal Republic of Nigeria, 1999, obliges citizens and unfettered access to justice. Whenever you have any of your rights being violated, the Constitution gives you opportunity of approaching a court of law, where we ensure that all the people, regardless of their background and their personal circumstances, can protect their rights, they can seek legal help, they can receive fair treatment under the law in order to close the gap in the accessibility, to close the gap in the effectiveness, and to close the gap in the efficiency of justice. But as important as justice is to human existence, a recent impact report on rule of law and anti-corruption in Nigeria confirmed that justice is not accessible to many Nigerians many citizens in Nigeria, and this limits their capacity to challenge crimes, it limits their capacities to challenge abuses and to challenge rights violations. The report further established that a significant gap exists between the justice need of citizens and the services available to meet those needs. If I may ask, let me pause here and ask a question. Can there be justice where there is no court established to entertain the subject matter of dispute between litigants? That's the first question. Could there be justice where available courts are not properly constituted with experts in the particular aspect of law applicable to the dispute between litigants? Let me share my experience and the kind of questions I used to put to my students while in the academy. If, as an indigenous of Oyo State, I wake up one day and I have a group, we go to House of Assembly with the executive to demand for establishment of Sharia Court of Appeal in Oyo State. I said, what will happen? The following day I will make headlines. I will definitely make headlines. One fundamentalist, one so. And the issue of access to justice is beyond that. As we will see now, majority of cases, I have listened, majority of cases, I can say 90% of cases, coming for determination and adjudication before Marco Customary Court, they bother on issues of Islamic personal law, and it is customary court that is deciding them. While I was in practice, there was a day I appeared before my Honorable Justice Ilorin, now JCA, in Shaki Judicial Division. And there was this dispute where two sections of Muslim community were fighting over who becomes an imam. And I asked this question, does this court have jurisdiction? And this is a grievance. People are fighting over this. There must be an impartial panel that will decide their grievance. And there is no such court available in Oyo State. Where should they go to? Number two, assuming the High Court with its unlimited jurisdiction cannot close its eyes, cannot close its doors to anybody that wants to access it for justice. If a matter should come before me that borders on Islamic personal law, even though I am a Muslim, I don't have knowledge of Islamic personal law, that is enough for me to adjudicate on that matter. Will I not just jeopardize our jurisprudence in that aspect? Those are the questions we're supposed to ask ourselves. Can there be access to justice? There are a lot of other areas. I just digress into those. Let me give you another thing. That same case that came up before Justice Ilorin, I remember my Lord now said, please, you people should go and settle at home. I stood up then and I said, it was from my local government. We will see to how this matter settled amicably. In the course of our intervention, I now stumbled on a criminal case out of the same fact. They have committed crime, they've been reported to police, the police have pressed charges against them, and they've been arraigned before Ojewode Magistrate Court. And her worship there was honest and sincere to them. I'm a member of the Igbo. If the two of you, imams, you can settle yourself, one of you will go to jail. If tomorrow, if you like, go to social media and say one redeemed pastor has sent an imam to prison. Can you see that kind of a thing? Ladies and gentlemen, in the southwestern Nigeria, the Muslims have a sizable population, but Islamic law applicable to some of their peers seem to be disfavored in that region. This is not issue of sentiment. Some scholars hold the view that Islamic law is territorially limited to the northern part of the country, and to that extent, it is not applicable to the southern part of Nigeria. I remember in the course of this work, I stumbled on the work of one of my colleagues, Professor Kareem Adedokun of Lasso, and he has this to say. Several judicial authorities have also held that the regular civil court lack the jurisdiction to entertain disputes bordering on Islamic personal law. The danger, according to him, this line of thought is revealed in the case of Afini and the president and members of Grade B Customary Court, where the Lagos High Court held that the customary court cannot dissolve a marriage conducted under Islamic law. The practical implication, therefore, is that litigants who are subject to Islamic law in southwest Nigeria and other southern states are potentially denied access to justice because of the absence of Islamic courts in the region, and on the assumption that the civil court cannot apply Islamic law. End of quote. Most recently, on 8th day of April 2024, I think we have another one in this December. The Oyo State Customary Court of Appeal, Party L. Abdulgani, PCA, held in a similar case that Grade A Customary Court have no jurisdiction to entertain cases concerning Islamic personal law, and that the fact that there is no court properly and validly vested with jurisdiction over a subject matter is no reason to bring that subject matter to a court not validly vested with jurisdiction to entertain that subject matter. Then where do they go to? But the dilemma is, since customary court lacks jurisdiction and high courts cannot adjudicate on matters of Islamic personal law, which court can the Muslim litigant go for issues involving Islamic personal law, particularly in the whole of southern Nigeria, where there is no single Sharia court? And that is the implication of, and what is the implication of that to society? The implication is simple. It's very, very simple. Lawyers from the judicial division where I sit can attest to the fact that there is no single day I don't take their first case. And this for these quarters, NJC said we should be remitting 6 in a quarter. And I think I have close to 20 now. We are coming to that. Due to the assistance of technology. Out of that 20, I can tell you 15 of them, they are on divorce, dissolution of marriage. Marriages contracted under the Act, the one we call statutory marriage. Now, if we have that one coming, at a time, Mr. Ajayi is here and some others, I ask questions. Do we have clergymen among lawyers? What do we do to enlighten people to make sure we reduce this thing to the barest minimum? And when you look at those cases that I pointed out, about 90% of them, they are marriages that are not up to 10 years. 10 years. 5 years. 2017, 2019, 2020, they are in court. In fact, some will come for leave because you cannot wait for 2 years. So, my Lord, give us leave so that as soon as possible we come for this solution because I need my peace. Now, if that happens to a marriage contracted under statute, tell me the one contracted under Islamic law, where divorce is simpler than what you can have under what do we call statutory marriage. And that is why we have a lot of people outside there. Today they are married, tomorrow they are outside married. What law determines the inheritance? What law determines succession? Because these people are people that profess faith different from the one that I court can entertain. And that is the kind of thing that we are talking about. With that as it may, I agree with the public commentator that those cases expose the weakness in the judicial system and access to justice in the southern Nigeria. Be that as it may, we have seen the gap now, the digital divide. We have seen that gap again in access to justice. That has the greatest implications for weak citizens. The significance of all the above earlier quoted statistical data is that there is a wide gap between those who have easy access to digital technology and the internet and those who do not, and that the difference significantly impedes access to justice. As many legal resources and services are increasingly moving online, so much so that individuals without reliable internet access or digital literacy may struggle to obtain legal information, may struggle to file documents, may struggle to connect with legal professionals. These create barriers for marginalized communities, exacerbating existing inequalities in the justice system, and this situation calls for need to do something cutting edge. It calls for something transformational. It calls for something that will improve delivery of justice, both in terms of quality and scale, particularly in this information age in which knowledge and information are increasing exponentially. Let's see the problem of access to justice. Before exploring the intervention of artificial intelligence, let us reflect on what hitherto characterized access to justice. Within the Nigerian legal environment, it's imperative to state that before I go in, let me pause a bit. I used to ask my students, I used to charge their head sometimes. I used to put these questions across to them. Can Nigeria be great? Can this country be great? After lengthy argument, some of them will agree with me, some of them will disagree with me. Even undergraduate and postgraduate students, some of them will disagree with me. Because for you to have a great nation, you need a stable, very stable government. And that government will bring about a way of managing conflicts, a way of managing law and order, a way of encouraging civil administration. If that is not in existence, there is a problem. If it is in existence and it is not well articulated or explored, there is equally a problem. Let's look at what we have today. Can Nigeria be great? I put that question to all. But my own answer is that Nigeria cannot be a great nation. If you allow me, and that is why I appeal, ladies and gentlemen, that's why I appeal to gentlemen of the press that whatever I say here, please don't take them out of context. Let me conclude that statement before you agree with me or you will disagree with me. Nigeria cannot be a great nation if the individual citizens and governmental institutions stick to obsolete strategies that can no longer impact progress in its administration justice system. We need to change. Ladies and gentlemen, I have noticed one thing about change. I ask myself this question: what is wrong with our civil procedure rules? Are there no enough provisions there that can accelerate the cause of justice? Okay, recently, from the whole criminal procedure rule, we moved to administration of criminal justice law, Act and to states. These are procedural laws. What's wrong with them? Why do we still have criminal cases staying like 1 year, 2 years before they are determined? We like paying lip service. We want this change, we want this change. You will never see the kind of debate across the media when this thing was to come into operation. Now it has come since 2015 or 2014 till date. And what has happened? Has anything changed? I have civil cases that I have 6 volumes of a file for 7 years when we have not left required stage. 7 years. And when I ask how many witnesses do you want to call? The claimant will say I have 2 witnesses. The defendant will say I have 1. This one will say I have. I say all in all 5 witnesses. And it's taking 7 years. Is something not wrong with our psyche? Something is wrong. We don't like and we have to delete the junks on our brain for new ideas to come in. Let me tell you, if you carry a lot of things you carry from academics, my Lord Honorable Justice F. Abraham, and you go to the bench and you want to implement it now, you will face discouragement from members of the bench first. Election petition, you have a file where a party wants to call over 200 witnesses and to tender about 500 documents, and you give me within 180 days I must do justice. If I don't leverage on technology, tell me how will I do that? And we are recording in manual, and that's why on a daily basis you see judges falling down and dying. A lot of people will see the glamour. Oh, they've increased their salary. They've increased it, they've increased that. Please go there for 1 month. You will want to come out the next month. I'm telling you. We will see now. By the time I'm rolling it out, the statistics from my own judicial division, from my jurisdiction, which I believe is what is applicable in others, in Kwara, you will see that we have a lot to do. The members, the bar, the bench, and all other stakeholders in the administration of justice. Now, year in, year out, successive government in Nigeria keep exerting efforts at winning foreign investors, but our individual and institutional attitudes are sending wrong signals capable of discouraging influx of foreign investors that can boost our economy. Do you need to woo them? Do you need to woo them? I remember we were taught, do I need to put a big signboard? This is Ayoba Ajayi and Co. I have never seen it in front of the officer. Before I entered that office, I was looking, each time I passed. It is what you do that will advertise you and that will bring people to come to you. That is the way it is done. So do we need to go cap in hand? Please come and invest in Nigeria. They will look at a lot of things. If I commit and sink my investment into this jurisdiction, what is likely, what is going to be the likely outcome? Dispute resolutions and access to justice, they are key factors that a businessman is likely to consider before seeking his investment in a jurisdiction. No investor will like to establish business in a country where his business survey reveals that the justice mechanism in his target jurisdiction are unnecessarily and irritatingly delayed and complex, where the environment does not enable access to legal information and resources which may enlighten and animate residents about their legal rights, or where insecurity is the norm rather than an exception. In summary, some of the problems of access to justice are this: lack of funds is one. Some litigants cannot afford the logistic cost of access to justice, such as lawyers' fees. Several instances you will see litigants come before you. Where is your lawyer? And say, we have not engaged one because we are gathering money to engage one. They don't have money. Sometimes you look at a claimant and you look at the defendant, you will see this financial imbalance. This one has the financial wherewithal to pursue his case. This one does not. And it will definitely affect that case. Not in the aspect of corrupting the judges, but in the aspect of hiring a job for you. So lack of fund is one. Ignorance of litigants is another one. Some litigants do not know that time run against them. Statute of limitation. They will go home, they will sleep there. It is when they decide, oh, we have gathered enough money and want to go to court, they discover that, oh, at the registry, the matter is there. They are bringing it to court, like I used to say, for a decent area. If there is delay in disposal of cases, that is where we have problems. That's where we have, and what is causing it? A lot of things. One of it is congestion of our courts. From my own state, I say it, there is no single judge that has less than 1,000 cases in his docket. There is no single judge. All these things will be done manually. It is not as if the judiciary will give you laptop to operate. Without I look at it. If I have 1,000 cases before me in my docket, each quarter of the year, I must give 6 judgments before NJC will know that I am performing. Now, in this era of technology, the way I was taught before I left academics is that if your next promotion, you have to present 5 papers. My professor told me, prepare yourself for 10 papers. Because when the nature of this time, when you get to where the meeting, the promotion meeting, appointment and promotion committee, your enemy will be there. You say, no, this paper will not go. If they hate you, before they remove 5, you will get to the 5 they need and you will stay through. And that is the same thing I take into judiciary. Even cases say we should present 6, at least. I am tired of these quarters, I cannot present at all. I'll present 8 or 10. Now, but we are having one problem with NJC. What is the quality of the judgment that we are submitting? Is it quality that NJC needs or quantity? When some of these judgments are not weighted, they are supposed to be weights attached to each of these cases. I have a criminal matter that I've taken 17 witnesses of the prosecution before we will move to that of defense. And the last time, my now married brother only just followed the show was for the defendant before he left. Before he left, that was the last appearance. So I said, how many witnesses did you call? He said, my Lord, we are calling 50. As you see, why would there not be congestion in our court? But if we leverage technology, these problems will be reduced. That is the angle I am going. What about attitude of counsel? I am sorry, I practiced for, I think, 20 years and above before I joined the bench. 20 years. And to the glory of God, I appeared before all sorts of courts, including Supreme Courts, before I joined judiciary. Now that I am on the other side now, I am seeing lawyers different from what I used to see when I was. And then I ask myself this question: was this the way I was behaving while I was here? Attitude of counsel. There are a lot of things there. And the Constitution says you must give them access to justice and fair hearing. Apart from that, we have disposition of judges and lack of digital skills. That's another problem. Of recent, I was at the conference of NJC, and a learned brother from another state asked, if you want us to align with this technology you are talking about, NJC, please make sure you deploy people that will come and teach us how to use computer, laptop. So that at this age, and one person gave a good answer. Said, do you have a grandchild? Said, yes. God will teach you. At the time that I appeared before one international organization that came to interview us for the position that my brother mentioned, Director General of CITN, I remember that auditing firm asked me a question. Please, may we know, can you tell us in percentage your knowledge of computer, your computer literacy? So I look, because I was coming from academic, I look like this. I said 65. They said, wow, this is the person we are looking for. 65%? Said good. It means you know more than those that constructed this computer. Because they said they did not on their own understand 5% of what they did. You will discover some of these things the way you interact and intimidate yourself. You can't distance yourself from technology, and you want technology to assist you in the delivery of justice. So that lack of digital skill, some courts are ill-equipped. Lack of provision for factual hearing, that's another. Our own civil procedure rules now ask factual something. How can somebody want to testify in a diverse matter where the husband wants to come and testify, the wife will testify, two witnesses and they will close their case, and he has to travel all the way from Germany to Nigeria, all the way from Germany. I think I have stopped that in my court, and it will never come up again. What I do is factual hearing. Factual hearing. This year alone, I can say that I have taken more than 10 from UK, from Germany. If we are entertaining fear of having interaction with this technology, we will not understand the challenges there and we will not know how to fix them. Go into it first. Sometimes if you have a witness, you will want to affirm or you want to swear, do you have a Quran there? Whatever you post, the other side there, do you know whether it's Quran or ordinary? You don't know. These are some of the challenges. But with time, we can overcome. Somebody may have a document and may be reading from that document. Put it here and we'll read it, I'll be looking. So sometimes when they are testifying, actually, I'll say, please look at me. Look at me. At least we have conducted exams like that when I was at CITN, and we have a way of knowing when somebody was cheating, even factually. So these are some of the things that we need, and before you know it, our access to justice and justice delivery system will definitely improve. Intimidation. The orientation and interest of litigants in this country when lawsuits are instituted is despicable. They take legal proceedings like a war that must be waged and must be won desperately. Desperately, including doing unethical things. That is not good. When you look at the totality of all this, in fact, some litigants are either threatening to abandon the lawsuit they instituted, or they threaten their witnesses from coming to court to come and testify. What is the intervention of artificial intelligence to some of these problems? The issue of artificial intelligence reflects a journey of innovation, setbacks, and breakthroughs, shaping the technology we experience today. Its origin is quite fascinating and dates back to the ancient times, but it really began to take shape in the 20th century. The idea of intelligent machines had existed for centuries, with myths and stories about automation and artificial being. Philosophers like Aristotle laid the groundwork for logic and reasoning, which are fundamental to artificial intelligence. The formal founding of artificial intelligence as a field occurred in 1956 at the Diamond Conference, where researchers gathered to discuss the potential of machines to stimulate human intelligence. History had it that John McAfee, an American computer scientist, coined the term artificial intelligence and was widely recognized as the innovator of AI due to his outstanding contribution. It evolved and developed over the years and became more integrated into everyday life, with applications in virtual assistant, search engines, recommendation systems, autonomous vehicles. Most recently, there comes into existence what we call robot citizen, created with a realistic human appearance and the ability to see and replicate emotions, as well as other AI tools and software applications that the use of algorithms to to perform specific tasks, solve problems, stimulate economic growth, and increase productivity. I remember when NBA Ogunmosho, I think last year, Bawi, my sister, Professor Amadou, came to present the paper on this. And I remember I made a comment because I just returned from a conference in Canada. That day, the presenter came and said, even your judgment, AI can write perfect judgment for you. I said, hey, this my work is now made simple. Then I come back home, I put all the facts, all the testimony of goodness and everything. And I was looking for AI to write a judgment for me. I did not say anything. So rather than having a misconception about what AI can do, it is a tool that can assist you in legal research that will make your work faster and will improve the quality. But it's not that human effort at all will not be there. We shouldn't go with that kind of mindset. Some of the problems of access to justice highlighted, although the concept of AI has been around for a significant period, its utilization in the legal field has been recent advancement. Initially, AI adoption in the legal field was limited to the largest law firms handling significant cases and deals. However, over time, the application, the developers, and the users of AI in the legal operations in the legal field have expanded so much so that AI is now being employed in various legal tasks, such as legal research, predictive analytics, factual assistance, document automation, and compliance support. Some of the problems of access to justice earlier highlighted constitute serious conundrums that hinder societal progress and smear the image of our nation globally, and can upgrade, and the deployment of AI tools and constant interaction and familiarization with them can upgrade and clear those impediments. In essence, artificial intelligence can significantly enhance access to justice in several ways, which are this. I will quickly take those. One of it is enhancing legal research. The technological development in AI promise to disrupt the very foundation of how legal work is practiced and delivered. The shift towards AI-enhanced practice of law is significantly changing the role of lawyers and the structure of legal organizations. One crucial area where AI-powered tools are revolutionizing the delivery of legal services is research. According to Platform, an AI-enhanced application will be able to conduct legal research intelligently, eliminating the need for lawyers and law librarians to engage in research activities themselves. This development can allow lawyers to focus more on analyzing information instead of spending countless hours searching for it manually. Let me state that on any discourse about access to justice, government and policymakers, judges and courts, lawyers and legal professionals, legal aid organizations, community organizations, academics and researchers, and the public are all concerned stakeholders that have important roles to play, ranging from making law and policies, interpreting laws and accessibility to court, advocating for litigants, provision of free or no-cost legal services to people, educating and enlightening the people, study access to justice, issues to provide insight that can inform policy and practice, as well as giving constant feedback to access to justice. For these stakeholders to impact our legal system positively within their respective space, legal research is foundational to improving access to justice by empowering legal professionals, educating the public, identifying systemic barriers, supporting pro bono initiatives, and ultimately contribute to a more equitable legal system. Technology generally offers judges, lawyers, and law firms the opportunity to improve their overall efficiency and to adapt to a progressively agile working environment. As a matter of fact, conducting online legal research, solving the growing number of websites, has become more and more a part of judges' daily activities. Therefore, the use of search engines and text mining techniques can greatly increase both the quality and efficiency of legal research. In other words, artificial intelligence particularly can help legal professionals to quickly analyze bulky legal documents, case laws and statutes in order to speed up research process and ease lawyers and judges search for relevant information. AI tools such as raw intelligence can enhance the efficiency of legal research. AI will also help in optimizing court administration. Court administration plays a crucial role in ensuring that the judicial system functions smoothly and fairly. It encompasses a range of responsibilities such as case management, scheduling, and public access to court services. Intelligent algorithms can automatically schedule court dates and times, thereby getting through hearings, trials, and other legal proceedings properly coordinated to minimize delay and optimize the use of court time. It also facilitates case tracking by providing updates on status changes, upcoming hearings, necessary actions for involved parties. This helps to keep everyone on the same page and reduces the likelihood of missed deadlines. To reduce overwhelming backlog of cases, AI tool known as RELEX, used in the European Union, can be adopted to automate case management and reduces administrative delays in Nigeria. Experience has shown that in an election petition, where hearing and delivery of judgment is restricted to a specific timeline, both lawyers and judges may have bulky processes and documents to contend with. For instance, a party may miss over 200 witnesses to court, improving its case, have more than 500 documents to tender, and the court proceedings are taken manually. By leveraging AI tools, efficiency and effectiveness in managing bulky court documents may be enhanced, and this will ultimately save time and resources for legal practitioners and thereby improving overall legal processes. We have personalized legal services. Nowadays, you see the knowledge of people about legal terms and terminology is increasing. And that's why on a daily basis, ask even ordinary Nigeria going on the street now, the moment he knows how to use this smartphone, he will tell you what defamation, criminal defamation and civil defamation is. He will tell you now. Because of what? The moment they have this issue popping up, they will quickly go, what's this defamation of the thing they are talking about? All this kind of personalized knowledge, without coming to a lawyer for consultancy again, you will see them knowing it. And that's why you see some of the litigants, they are more lawyers than the lawyers themselves. They will tell you, Oga, you can find this motion to fight that and it will work. Because some of them have accessed AI and they know some of this. This improvement facilitates access to justice by enabling individuals from underprivileged backgrounds who would otherwise not afford traditional methods access top quality service at affordable rate, which ultimately increases efficiency. The next is predictive analytics. It entails the use of statistical techniques, machine learning, data mining to analyze historical data, make predictions about future events or threats. It involves identifying patterns and relationships within the data to forecast outcomes, allowing organizations to make informed decisions based on insight. Essentially, it's about using data, past data to anticipate what might happen in the future. When you interrogate, when you integrate AI into this, you will be able to predict the outcome of your case. Let me point out this. There is one phraseology that negatively impacts access to justice. It is likelihood of bias. Likelihood of bias when you want to invoke the supervisory jurisdiction of a high court. We want high court to supervise the proceedings of inferior courts. One of the grounds is proved likelihood of bias. It's used to occur in legal and quasi-legal proceedings when there is probability that certain prejudices and stereotypes can influence decisions and actions in a particular way. It manifests in situations where there is personal animosity or hostility. You may have that for a lawyer. Please don't forget, judges are human beings. They are human beings. When they say we should exercise our discretion, and the discretion that I exercise, that of my Lord, Honorable Justice F.F. Abrasa, cannot be changed for my own. That because the law cannot capture all the things, the law cannot envisage everything that will happen. Therefore, there will be instances where judges will have power to exercise discretion. So you have personal animosity for somebody who is appearing before you. I'm not saying judges you to use that, but literature says it is a way of having likelihood of bias. Apart from that, what about personal association and friendship? I have a colleague at Osun State that told me his practical experience. That Odua University, the faculty of law there organized a program. They invited the CJ of Osun. The CJ could not go, and said the CJ asked him to go and represent her. When she got there, after there was time for photograph, and she took photograph next to that man, that the owner of the university. At a time that that man has a challenge, he's been arraigned for criminal act. The case was assigned to that job. Instantly, he said he went to CJ and said, "My Lord, I decline taking this case." Should he take that case that day, the following morning? You think you are the only one that have that picture? Social media will be awash. See the judge with this man, and they will be saying a lot of things. And that's why you see, coming into this side of this work, it has taken away a lot of things. The way you are saying, "My Lord Justice F.F. Abrazak" before, it may not be like that now. The Asalatu she's attending may not be like that now. You may not know. Some of these people are fraternizing you, so that when there is time for you to pay them back, they will tell you, "Happy you have forgotten." And issue of justice is more than that. The question I used to ask myself is this: one day, Honorable Justice Adedokun will stand before another judge that will ask me, "How did you?" So what will I say? Will you be there? It might be in my grave. It may be on the day of judgment. What will I tell God? Because of that, no influence, no matter how highly placed. And that is it. Ladies and gentlemen, let me use this opportunity. We shouldn't join others in running down our judiciary. The fact that you have just one bad egg does not mean that all of us are bad. It does not. I used to ask people, "Are you saying I don't have my name and integrity protected before I came here?" You think it is a day work before somebody will rise from scratch to associate professor or professor of law? We have professors. Even in this new appointment, we have them in higher schools. As far as my own state is concerned, appointment is on merit. I don't know anybody before I got my own appointment. I can say it anywhere. I was coming from class to class. I did not. I was coming from class. I used to take accounting, business law, and company law. I think I was taking them company law. And I was coming from class. I have seen some of my students here. From tourism center. And the phone entered. I don't usually pick a number. I don't know that they are kids. Is this Dr. Adedokun from social? I say yes. And I remember before that time, I discussed with my boss, President MMA Akanbi. Okay, this one that we have some people on the list dying. My name is there, but I can't tell anybody. My name was on that list as substitute, but I cannot tell anybody. Okay, I said, "Hey, please keep on praying. Keep on praying. Keep on praying." And we kept on praying. Coming from that class, my phone rang, and they are you Dr. Adedokun from class? I said, "Yes." May I know his speaking? The person mentioned his name. So we want to ask you, in view of what happened, we are moving your name from substitute list to the main list. Do you have any objection to it? I said, I don't have. Who called me? I don't know. The same time, from the same class, the following Thursday, as I was coming out, I received another call again. You have a letter from NJC for interview. Then I look myself, come and do it. Will this thing happen? It was when it happened. I did not know. So, Dr. Salam is here. Thank you very much. I did not know how people went on that ground to find out who is this type of person, even here. I did not know. I just heard from my secondary school and primary school. They came to look after your document. I said, why? I did not know. My mom called me. My mom is over 100 years. And she's alive here and here. They called my mom. Are you the mother to those who say she was? Oh, he did not do anything. They said, no. Are you at home? He said, they went into my home. That's my humble beginning. To find out whether this man is worthy of being appointed a church. And the emotional type, I don't want to go to this. It was after that I knew that the exam that we did, the interview that we conducted, you are number so. This is your something. This is your number. And that's why we thought, oh, what about that man from Kwaso? I did not love it. This last one, there was no love it because I am already an insider and I know how it happened. You see, for exam, that you are CR does not mean automatically you will get it if you do not pass. That is the kind of thing. The only thing I will plead for in all our judiciaries to add into it is that in this era, digital literacy should be one of the things we will consider before appointment. It will help all of us. Ladies and gentlemen, addressing these biases is crucial for improving access to justice. Utilizing tools like predictive analysis, it will enhance. Let's look at the challenges now. We want to use artificial intelligence to obviate all the problems. What about infrastructural limitations? It's not everywhere. Many areas in Nigeria face inadequate internet connectivity, technological infrastructure, and this can hinder effective development and the use of AI tools. What about digital illiteracy? You can imagine a judge that is saying you should come and teach him how to operate laptop this era. Digital illiteracy. What do we do? That is the challenge. Data privacy and security is an important, even though we have Nigeria Data Protection Act in 2023, but it still trade along a very serious controversy. The question is this: data privacy is a human right? Data privacy is a fundamental human right. There are two different things. A right is fundamental, is basic to you, to your existence, and that is why the Constitution is not the one that gives you no right. The only thing that the Constitution provides for is that those rights are protected and guaranteed. They are given to you by God. Rights to talk, that's freedom of speech. Rights to walk, that's freedom of movement. All these things are there. If you have a child and that child does not walk after 2 years, you feel worried. If that child does not walk after 2 years, you'll be worried. Because these rights are important to us, the Constitution says they are protected and guaranteed. What about data privacy? There are two schools of thought. One school of thought said no, it is not part of human rights. Another school of thought said no, it is part of human rights. Recently, Supreme Court has brought a respite on the issue of data protection in Nigeria. In incorporated trustees of digital rights lawyers initiative and others against National Identity Management Commission, because of our has cleared the conflict occasioned by the decision of High Court on the status of data protection rights in Nigeria, when it held that right to privacy of citizens as guaranteed under Section 37 of Constitution includes the right to protection of personal information and personal data protection. All of cultural and language barriers, particularly considering the heterogeneity nature of Nigeria, cost implication. Developing and maintaining the IR system can be costly, and the legal aid organization may struggle to secure funding for such technologies, limiting their availability to those who need them most. There is no clear-cut regulatory framework that will govern the use of AI within the legal sector, and this can lead to uncertainties about accountability and the ethical use of AI technologies. Ladies and gentlemen, addressing the above challenge is essential for ensuring that AI can effectively enhance access to justice in Nigeria. As a matter of fact, legal organizations can invest in infrastructure by collaborating with government and private sectors to improve internet connectivity in underserved areas, enhance digital literacy, implement strong data protection policies, develop multilingual AI solutions, seek funding and partnership, and engage with policymakers to advocate for a clear regulatory framework. By taking these steps, the potential of AI to improve access to justice in Nigeria can be enhanced, and the Nigerian legal system may be more inclusive and effective for all citizens.